আপনাদের সকলকে আমি আবারও আমন্ত্রণ জানাচ্ছি আজকের ক্রিমিনাল ল এর উপরে আইন বিষয়ক অনুষ্ঠান ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি আজাম এন্ড কো সলিসিটার্স এর প্রিন্সিপাল সলিসিটার শাফিউল আজম। আপনারা জানেন এই প্রোগ্রামটা আমি লাইভ প্রোগ্রাম করি সানডে, এবং কাল সোমবার এই প্রোগ্রামটা আবার রিপিট দেখানো হবে এনটিভিতে সকাল 9:30 থেকে 11টা পর্যন্ত। আমরা আজকে দেখাচ্ছি প্রেস্টন ক্রাউন কোর্টের জাজের ছবি আপনারা দেখছেন। সে একটা মেয়েকে 22 বছর বয়স্ক একটা মেয়েকে সাজা দিয়েছিল 8.5 বছরের জেল হাজত, কারণ সে পুলিশের কাছে অনেক ফলস সেক্সুয়াল অ্যালিগেশন করেছিল এশিয়ান লোকজনের বিরুদ্ধে, এবং এগুলো সে মিথ্যা বলেছিল এবং মিথ্যা প্রমাণিত হয়েছে। জাজ অনেকগুলো একের পর এক বলে গেছে, আপনারা শুনছেন এবং আমরা আরো কন্টিনিউ করব, এটা দেখবেন আপনারা। এতে আমি আরেকটা বলবো যে সে বলছিল কি পুলিশের কাছে, হ্যাঁ, she when police made inquiries they found she had traveled to the আপনার seaside resort alone and stayed in a hotel। বলছিল কি সে পুলিশের কাছে যে ওই মেয়েটা gave police an account of being taken to Blackpool, তাকে ব্ল্যাকপুলে নিয়ে যাওয়া হয়েছিল। when she said this man, Asian man, threatened her, তাকে হুমকি দিয়েছিল, and she was taken to different addresses, তাকে বিভিন্ন অ্যাড্রেসে নিয়ে যাওয়া হয়েছিল, forced to have sex, তাকে জোর করা হয়েছিল সেক্স করার জন্য, উইথ ম্যান মানে ডিফারেন্ট ম্যান অনেকগুলো মানুষের সাথে বলছে সে। তারপরে when police made inquiries, পুলিশ যখন এনকোয়ারি করেছিল তখন পুলিশ দেখতে পারছে কি they found she had traveled to the seaside resort alone and stayed in a hotel, যেখানে দেখা গেছে সে একটা সি সাইডে একটা রিসোর্টের মধ্যে ট্রাভেল করেছিল, যেখানে সে একটা হোটেলের মধ্যে একা একা ছিল। where she bought a pot noodle from a nearby shop, আপনার পট নুডল মানে ওই যে পট নুডল মানে একটা পটের মধ্যে একটা নুডল খাওয়ার জন্য সে কিনছিল একটা নিয়ার বাই শপ থেকে, and then remained in her room watching YouTube on her phone, এবং সে রুমেই ছিল এবং সে ওয়াচ করতেছিল আপনার বিভিন্ন ইউটিউব ভিডিওগুলো তার মোবাইল ফোনে, ওই তখন সে হোটেলেই ছিল। এবং সুপারিনটেন্ডেন্ট অফ পুলিশ, ওকে, তখনকার যে ইনভেস্টিগেশনের যে সুপারিনটেন্ডেন্ট ছিল সে বলছে কি যে কামব্রিয়া পুলিশের, এটা কামব্রিয়ার মধ্যে এই ঘটনাটা ঘটেছিল, এলিগেশনস লেড টু পাবলিক ডিসপ্লেস অফ ম্যাস অ্যাঙ্গার। আর এতগুলো এলিগেশন হয়েছিল, এখানে একটা বিশাল পাবলিকের একটা মানে আপনার পাবলিক ডিসপ্লেস অফ ম্যাস অ্যাঙ্গার ইন বারো, with protests hold outside the police station and on a retail park। অনেকগুলো প্রটেস্ট হয়েছিল আউটসাইড দ্য পুলিশ স্টেশনে। সে এত বেশি এলিগেশন করেছিল, এটা একটা হিউজ একটা রিয়াকশন করেছিল পাবলিকের মধ্যে, তারা খুব অ্যাংরি হয়েছিল, তারা অনেক প্রতিবাদ করেছিল পুলিশ স্টেশনের সামনে এবং পার্কের মধ্যে, অনেকগুলো আপনার এগুলো হয়েছিল। and in a letter read to the court, একটা চিঠি সে কোর্টের কাছে লিখেছিল, এই মেয়েটা বলছিল সে লিখছে কোর্টের কাছে, she had not investigated anything which happened in the community। সে কমিউনিটির মধ্যে যে এত বিশাল একটা প্রতিক্রিয়া দেখা গিয়েছিল, যে প্রটেস্ট এবং যে তারা যে মানে বিভিন্ন জায়গায় জড়ো হয়েছিল, পুলিশ স্টেশনে গিয়েছিল প্রতিবাদ করার জন্য, সে বলছে কি that she did not instigate anything which happened in the community, এই কমিউনিটিকে উত্তেজিত করার জন্য এমন কোনো কিছু সে করে নাই, and did not want আপনার রবিনসন to come to the town। আর একটা ওই একজন লিডার, কমিউনিটি লিডার, সে বলছে আমি চাই নাই ওই ব্যক্তিটা এখানে এই এলাকার মধ্যে এসে জড়ো হোক, মানুষদেরকে জড়ো করুক, এগুলো আমি চাই নাই। আরো অনেক অনেক কথাগুলো বলছে। আমি দেরি না করে আমার বক্তব্যটাকে সংক্ষেপ করে আপনাদেরকে আমি শোনাবো জাজের স্পিচটা। দর্শক আপনারা আমি কন্ট্রোল রুমকে আমি এখন রিকোয়েস্ট করছি আপনারা জাজের স্পিচটা আপনারা প্লে করেন প্লিজ।
Turn to count 7. On the 18th of July 2019, the defendant caught a train to Leeds. The clear evidence is that she spent a good part of the day in the park. She had 2 phones with her. She then travelled back to Preston, where she walked into the town centre. A young man walking home from a family party happened upon her. He asked her for a light, and they started to talk. They had a brief and entirely consensual sexual encounter. The defendant then caught the train to Barrow-in-Furness, exchanging details with the young man and tentatively agreeing to meet him at a later date. Once in Barrow-in-Furness, she walked to her flat. Her brother's girlfriend happened to see her as she walked her home, picked her up and took her home. Much of this, including much of what happened in Preston, was caught on closed-circuit television. By now it was the early hours of the 19th of July. Once her brother learned from his girlfriend that the defendant was at home, he called the police. Everyone had been frantically worried about her all day, and she had been ignoring their messages. When the police arrived at her house, the defendant pretended to be semi-conscious. The jury and I saw body-worn footage captured by the officers. It's clear that the defendant was play-acting, pretending to be semi-conscious. She was injured, but the clear evidence was that she had inflicted the injuries upon herself. She then created a false account of what had happened in Leeds, Preston and Barrow that day. All of this account was inconsistent with CCTV, telephone and other evidence. She told the police that on Wednesday the 17th of July, a man called Salza, an invented trafficker, came to her door. He'd slapped her in the face, pinned her to the wall by the neck. He told her to follow orders she would get on Snapchat. He said that she had lost them money and she needed to earn them £10,000 as a result. She said that she was then told to go to Leeds. There she was taken to a house where she had sex with 2 men. She and a girl called Molly then walked to another premises. There were other girls there. There she said she had sex with 3 men. She was then driven to a chicken shop in Headingley, where she had sex with another man. She then said she was driven to Bramley and then to Bradford, where she had sex with 3 men. She then saw her passport on the table with a ring on it and flight details to Bangladesh, so she ran. When the traffickers were able to contact her by phone, she was told to go to Preston. She said that the young man she had met in Preston was a trafficker and that he had sent her a message telling her that he had lined up some cocaine on a bench and she had no choice but to take it. She said that he took her to 2 Asian men who paid him to have sex with her. She then said that the young man himself then took her down a back alley and raped her. Eventually, she said, she was allowed to return to Barrow-in-Furness. Salza met her at the train station and he drove her home. We have seen the video footage of her walking home. She said that when she opened her door, he and another man forced their way in and she was forced to have sex with them both. Salza struck her in the face and told her to sort herself out and that they would be back for her at 2 a.m. 10 minutes later, the police arrived and she could not recall anything further until she woke in hospital. This was a complete fabrication. Much of it could be disproved from CCTV in Preston and Barrow-in-Furness. What happened in Leeds was shown to be false by the location of her phone. She had, during the course of the day, created other evidence to support the false account she knew she would give. Most notably, she had used one of the 2 phones she had with her that day to send messages from a person she described as Nicole to herself. She'd then taken screenshots of those messages. Nicole was supposed to be a fellow trafficked woman who was being raped at the parties. Nicole was supposedly angry at the defendant for leaving her and the other victims in Leeds. However, the agreed evidence was that when Nicole was apparently complaining about being left in Leeds by the defendant, The phone from which the messages were being sent was with the defendant on the train back to Preston. She was sending the Nicole messages from one phone in her possession to the other phone in her possession. I turn now to count 8. In May 2020, the defendant was on bail for perverting the course of justice. It's clear that she was still intent on trying to invent evidence to support her previous accounts. In the earlier part of 2020, the instances of her apparently going missing and turning up intoxicated and injured had increased. On the 18th of May 2020, she set out from home on foot. It's clear from the evidence that she never left Walney Island and never entered a vehicle. At 22:49, she was found by police in fields close to her home. She had multiple injuries. One eye was swollen shut. She had hammer injuries to her legs and abdomen, which were too numerous to count. Part of her little finger was partly severed. These injuries were all self-inflicted. Her account was that she had intended to catch a bus to travel to Barrow, but one of the males associated with those who'd exploited her offered her a lift, which she accepted. She then said that she was taken to a house in Barrow-in-Furness. There were 10 males there. She said that a number of named men raped her at that property. One of them assaulted her and tried to cut her finger off. One of them drove her back to Walney Island. She walked off to where the police found her. A few days later, the police found a hammer, which she had purchased some days before. It was hidden against a fence close to where the police had found her. It bore traces of her blood and DNA. A Home Office pathologist gave evidence to the effect that the serious injuries she had sustained were completely inconsistent with her account and completely consistent with being self-inflicted with the hammer which she had bought, which was found close to her and which bore her DNA. On the 20th of May 2019, the defendant made a Facebook post in which she posted shocking photographs of the injuries she had inflicted upon herself. These photographs were very graphic and bound to produce a significant response. In that post, she referred to these having been inflicted by 3, as she put it, Asian men, as they took her to various sex parties. In that same post, she referred to having been similarly abused by Asian men and men of Pakistani origin in various locations across the north of England for a number of years. She said that she would continue to tell the police everything she knew. She encouraged parents to be vigilant and children to speak out if they were concerned. She did not mention that she was already on bail for perverting the course of justice. I turn to count 9, to which the defendant pleaded guilty. This admission represents her writing a letter from custody to her sister, asking her sister to tell her, that is the defendant's solicitors, that a hammer had been found in her bedroom. This was an attempt to create a false defence to count 8. When she entered her plea, it was on the basis only of what she wrote to her sister and not what was said to her mother. In the context of this case, it is not necessary to decide that issue, and I will sentence her on her basis. The defendant is 22. She had no convictions prior to these matters coming before the court. I note that she was under 18 at the time of the commission of count 1. She had turned 18 by the time all other offences were committed, but I bear in mind her young age and the principles set out in the guideline in relation to sentencing children and young people. Though she was an adult at the time of the commission of the vast majority of this offending, I must bear in mind her maturity as well as her chronological age. There is evidence that she is immature. Apart from her age, there is some other personal mitigation. There are clear overtones of difficulties in her childhood. She's been self-harming from a young age. However, there is little clarity about what these difficulties involved. It is mitigation that before this offending she was of good character. It is troubling to say the least that she shows no significant sign of remorse, even continuing to profess the truth of her allegations. The only flicker of appreciation of what she has done came today, with a brief note read by her counsel regretting the effects of her post on the 20th of May 2020. I've received much psychiatric evidence in this case, all of which I've read. I heard evidence yesterday from Dr. Bacon called on behalf of the defendant. Dr. Bacon maintains that the defendant has a complex post-traumatic stress disorder. Dr. Locke, who has provided a report for the Crown, does not accept that this is a conclusion which can be drawn, given that there is no satisfactory account of any antecedent trauma. I agree with the conclusion of Dr. Locke that there is no evidence upon which I could conclude that there is a complex post-traumatic stress disorder. Since she has been found guilty, the defendant has hinted at other sources of trauma, but has given no real indication as to what it could be. Of course, I've considered whether the aberrant nature of these offences means that I should assume that the defendant is suffering from some mental impairment. There is no explanation for why the defendant would commit these offences. She has gone to extraordinary lengths to create false accusations, including causing herself significant injury. No explanation for this behaviour is apparent. However, that does not mean that I should speculate. Unless and until the defendant chooses to say why she has told these lies, we will not know. In any event, I question the relevance of the defendant suffering from a complex post-traumatic stress disorder in relation to sentence. When Dr. Bacon gave evidence yesterday, I asked her to comment on whether such a condition could reduce the culpability of a person to be sentenced for perverting the course of justice. Dr. Bacon had told us that this was not within the scope of her instruction from the defence. When I asked the question of Dr. Bacon, Ms. Blackwell, KC, intervened, telling me it was not the defence case, that the defendant's complex post-traumatic distress disorder, if that is what she has, is relevant to culpability. I do accept that it is part of her personal mitigation that she has vulnerabilities that I will take into account. I turn to the structure of the sentence. The count which concerns C and the counts which concern Mr. Trencove are separate from each other and from the other offending in this case. However, the offending at counts 5, 6 and 7 can properly be regarded as a course of conduct. Counts 8 and 9 are together part of the same course of conduct, and whilst they could be seen as part of that represented by counts 5, 6 and 7, they concern a separate incident and were committed on bail for other matters. I intend to impose concurrent sentences on counts 5, 6 and 7. However, there will be a consecutive sentence on count 1. There will be additional sentences on counts 2, 3 and 4, concurrent with each other, but consecutive with the other sentences. There will be further sentences on counts 8 and 9, concurrent with each other, but consecutive to the other sentences, save that I will temper the structure of these sentences to give effect to totality. There is no guideline for this offence, and I apply the general guidelines' overarching principles. The maximum sentence is at large. I've been provided with a number of authorities which I've read. There are no analogous offences for which there are guidelines. I consider first the defendant's culpability, then the harm. I consider the purposes of sentencing, and then the aggravating and mitigating features. I must then consider totality before arriving at my final sentence. The cases to which I've been referred provide the following factors, which are amongst those that I should bear in mind. I remind myself that because this offence strikes at the heart of the administration of justice, it is to be regarded as serious. Deterrence is an important aim of sentencing, though I must remember that when sentencing young people, this may be extinguished or diminished by the principal aim of the youth justice system is to prevent offending by young people, and I must have regard to the welfare of the defendant. This offence is fact-specific. Previous cases are of little assistance. When considering culpability, I must take account of the seriousness of the underlying offence. I bear in mind the nature of the deceptive conduct and the time over which it continued. I consider whether the offence cast suspicion on others, whether others were arrested. In this case, I'm asked to consider community impact. I'll set out in detail my approach in this regard. In relation to all counts, I bear in mind that these were allegations of sexual offences. These carry not only the risk of prosecution, but also a potentially indelible stain on the character and reputation of everyone accused. Sexual allegations, even
দর্শক, আপনারা শুনছেন জাজের স্পিচ। আপনার অনেকগুলো কথা বলছে, কিন্তু সময়ের অভাবে পুরা ভিডিওটা প্লে করা সম্ভব হচ্ছে না, কারণ আমাদের অনেক বাকি অংশটুকু যেটা আছে সেটা শুনতে গেলে আবার অনেক বেশি সময় লাগবে। আমি শুধু সংক্ষেপে দুই একটা পয়েন্ট বলবো, যেটা তখন আপনাদের একটু বুঝতে সুবিধা হতে পারে। এটা হলো কি, সে জাজের কাছে সে একটা চিঠি লিখেছিল। ইন দ্য লেটার টু জাজ সে বলছে কি, আই এম নট সেইং আই এম গিলটি। সে বলছে কি, আমি বলছি না যে আমি দোষী, বাট আই নো আই হ্যাভ ডান রং অন সাম অফ দিস, এবং আমি জানি এখানে কিছু কিছু ব্যাপার আছে যেখানে আমি ভুল করেছি। দ্যাট আই এম নট সেইং আই এম গিলটি, আমি বলছি না যে আমি দোষী, বাট আই নো আই হ্যাভ ডান সামথিং রং, আমি কিছু ভুল করেছি, এবং I am sorry, ওইগুলো যেগুলো ভুল যেগুলো করেছে সেগুলোর জন্য সে বলছে, and I am sorry, ওগুলোর জন্য সে বলছে। I am devastated at the trouble that has been caused in Bara. আমি খুবই মর্মাহত, খুবই মানে আমার devastated মানে বিধ্বস্ত, কারণ এইটা আমার যে অ্যাকুজেশন গুলো যেগুলো ওয়াইড স্প্রেড ভারতে পাবলিশ হয়েছে, নিউজে, মিডিয়াতে, ফেসবুকে, সোশ্যাল মিডিয়াতে, এবং এটা যে একটা ট্রাবল ক্রিয়েট করেছি, ইফ আই নিউ দ্যাট কনসিকুয়েন্সেস উড হ্যাভ কাম ফ্রম দ্যাট স্ট্যাটাস, আই নেভার উড হ্যাভ পোস্টেড ইট। আমি যদি জানতাম যে ফেসবুকের মধ্যে, সোশ্যাল মিডিয়ার মধ্যে এই পোস্ট গুলো দিলে, স্ট্যাটাস গুলো দিলে এত বড় যে প্রতিক্রিয়া হবে, এত বড় যে কনসিকুয়েন্স যেগুলো হবে, সেগুলো যদি ইফ আই নিউ what consequences would have come from that status, I never would have posted it. আমি কোনো সময় এটা পোস্ট করতাম না, এই কথাও সে বলছে। এবং ডিফেন্ডিং, তাকে ডিফেন্ড করতে গিয়ে, এবং said her client maintained the allegations were true. মানে ডিফেন্ডিং দ্য, মানে তাকে যখন বলছিল, said her client maintained the allegations were true, এখানে মানে মানে এলিগেশন সে বলছে কি এগুলো ট্রু, মানে বলে না যে এগুলো অসত্য, সে মানে বলছিল যে এগুলো সত্য, তার ব্যারিস্টার, তার লয়ার সে বলছিল। she said, she added, other than her personal vulnerabilities, তার যে দুর্বলতা ছিল, সে বয়সে অনেক কম ছিল, ওই পার্সোনাল ভালনারেবিলিটিস গুলো ছাড়া, and her age, এবং তার কম বয়স, এটা ছাড়া, and doesn't appear to be my motivation at all, any motivation at all, এটা কোনো আমার মোটিভেশন ছিল না এগুলো মিথ্যা কথা বলার, শুধু আমার একটা ভালনারেবিলিটি ছিল, সেটা হলো আমার এজ, এটা। এবং তার ব্যারিস্টার বলছে কি, এলিগেশনস ওয়ার ট্রু, এগুলো সত্য, কিন্তু মানে অনেকগুলো সে বলছে কি, আই এম নট সেইং আই এম গিলটি, বাট আই নো আই হ্যাভ ডান সামথিং রং, or some of these I have said wrong and I am sorry, এইগুলো সে বলছে। খুব মানে খুব পিক এন্ড চুজ করে করছে, আর সবগুলা ইয়া করে নাই। এবং শেষ পর্যন্ত সে আরো বলছে কি, আই এম ডেভাস্টেটেড, যেগুলো ঘটেছে এটার জন্য। দর্শক, আমাদের সময় শেষ হয়ে গেছে। আজকের প্রোগ্রামটা আপনারা কাল দেখবেন সকাল 9:30 থেকে 11টা পর্যন্ত এনটিভিতে আবার রিপিট দেখানো হবে। তাছাড়া এনটিভি ইউরোপের ফেসবুক, ইউটিউব, টুইটারে, ইনস্টাগ্রামে লগ ইন করলেও আপনারা এই প্রোগ্রামের লিঙ্ক পাবেন। আপনারা সলিসিটর শাফিউল আজম, আজাম এন্ড কো সলিসিটার্স এই নামে গুগলের মধ্যে সার্চ করলেও প্রোগ্রামের লিঙ্ক পেতে পারেন। সবাই ভালো থাকুন, সুস্থ থাকুন, এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।